them onto his own web pages. He has arrived. He has become wired. But does he have a copyright problem? Now, despite the geographically boundless nature of cyberspace, I don't have boundless time. So I'm only going to be talking about the United States copyright law. And under U.S. copyright law, the copyright owner is given the exclusive right to reproduce the work in copies subject to certain limitations. So we've got a few elements here to consider. Copies, right? What's a copy under the Copyright Act? Copyrightable works. What constitutes a copyrightable work? And what are these limitations that I refer to? So let's start with element 1, copies. What's a copy? Well, under the Copyright Act, copies are material objects in which a work is fixed and from which the work can be perceived for more than a transitory duration. Courts have held that even RAM copies are copies. Copies stored on your computer while your computer is on, that go away when you turn your computer off. They are sufficiently permanent and stable to constitute a copy under copyright law. So you can see that all of cyberspace is really just another word for one gigantic copying machine. It's all copies. Everything out there in cyberspace is a copy. And so what the professor has done in posting these law firm summaries clearly constitutes reproducing the work in copies. He's made some RAM copies, he's probably made some PROM copies, and he's now loaded another copy onto his law school's server to post them to his web page. All right, well, let's talk about element 2, right? What's a copyrightable work? Well, under the Copyright Act, the United States Copyright Act, a copyrightable work is an original work of authorship fixed in a tangible medium of expression. And when we talk about originality, as the Supreme Court tells us, only requires a modicum of creativity. Only a little bit. That's all that's needed to have something that's copyrightable. And so the summaries of these cases prepared by these law firms, in all likelihood, qualify. They have sufficient originality to be copyrighted. Now, the professor, one of the reasons he copied these things was there was no copyright notice. And so he thought, well, heck, there's no copyright notice, so I can freely copy. I can use that right-click button and just go right ahead. Well, ever since the United States joined the major international copyright convention called the Berne Convention, notice is no longer required for copyright protection. So merely because it doesn't have a notice doesn't mean it's not subject to copyright protection. So you can't rely on that. Well, all of these, I've now told you everything in cyberspace is a copy, and I've told you how little originality is needed to have something that qualifies for protection. What's not subject to copyright? What can we use out there in cyberspace without having to even think about copyright law? Well, facts and ideas. Copyright only protects the expression. It does not protect the underlying ideas expressed or the facts expressed. So we can clearly use those without worrying. There are some other things that are not subject to copyright protection that are very relevant to law professors. One is the works of the federal government. And that is provided for right in the statute in Section 105. All of the Copyright Act is codified in Title 17. So that's 17 U.S.C. Section 105. So agency reports, commission findings, any work prepared by a federal employee within the scope of their employment. All right, so certainly, therefore, we must assume that the STAR report's proliferation of copies in cyberspace was due to its lack of copyright protection and certainly not its content, right? Work of the federal government. And it's very important that this is the federal government, right? State governments, they don't have the same lack of copyright protection, and many states do assert copyright protection for works that their employees create. So it's only the federal government. All right, well, beyond some of the statutory provisions, specifically Section 105, there are some long-standing judge-made doctrines. Enacted laws are not subject to copyright protection. Right? We want people to be able to freely access those laws, so copy away. But be careful with model laws, because we do have some case law out there that says entities that create model laws have a copyright interest in those model laws, even after they've been enacted by either a state, most likely a state government, sometimes local county. counties, cities enact things like building codes. So the enacted laws are not subject to copyright protection, but model laws might be. We're still, and we do have some case law out there that says they are. All right, another major exception is judicial opinions. They are not subject to copyright protection. But be careful, because the summaries that people prepare about the judicial opinions, for example, West always prepares a nice little summary at the top of the opinion, and the head notes are not created by these judges. They are not part of the opinion, and they are subject to copyright protection by the entity that has created these summaries and these head notes. But the opinion itself is free for anyone to copy. Now, I've got a couple cautionary notes. One is a cautionary note about obtaining digital copies of either judicial opinions or enacted laws. You have to think not just about copyright law. There may be some contractual prohibitions on using digital copies from certain sources. For example, Lexis and Westlaw. As part of your subscriber agreement, there are very severe restrictions on what you can do with digital copies that you have downloaded from Lexis or Westlaw. Now, any breach of contract action that would be brought would be a state law action. Copyright is a federal law, and copyright has an express preemption provision. So because we've got this tension between state law and federal law, there are some very complicated federal preemption issues lurking behind any kind of state law breach of contract claim that might be brought. But as with Fairmont/Theorem, I don't really have room in this presentation to describe those for you. All right, well, the alternative is to obtain digital copies from some source that doesn't have these contractual restrictions. And there are a couple out there. FindLaw.com and Thomas are two excellent sources for obtaining judicial opinions. The FindLaw site has both Supreme Court, federal decisions, federal circuit court, federal district courts, and also state court opinions. FindLaw also has enacted legislation. The Thomas site is a great site for obtaining pending federal legislation, committee reports, enacted public laws, just a great site. And at the beginning of the presentation, I had a URL up on the screen where I have posted all of this on a website. So if you want, there's only one URL that you have to write down, and I'll put it up on the screen at the end of the presentation as well. All right, so you can obtain copies of public domain material from these sources and not have to worry at all about any possible breach of contract claim that might be brought. All right, well, I have another cautionary note about obtaining digital copies. And that comes out of our new federal legislation called the Digital Millennium Copyright Act, which some of us copyright geeks like to call DMCA, DMCA. The DMCA added something that we refer to, some of us have started referring to as para-copyright. It's not really a copyright right that's being granted, but it's a right to protection of the locks, the technological locks that copyright owners are beginning to put onto their works. And the protection that is granted is that we the public, individuals, cannot circumvent a technological protection that controls access to a work or that prevents reproduction of a work. All right, now this prohibition on circumvention for individuals doesn't take effect for 2 years from the date of enactment. So it will not take effect until October 2000. So currently, you can still circumvent the technological protection without running into Title 17 problems. You may have other problems, but you won't run into Title 17 problems until October of 2000. Right now, we do have a prohibition on the creation, manufacture, and sale of devices that are designed to circumvent these technological protections, or even services that are designed to circumvent these technological protections. That prohibition took effect immediately. So, don't break an encryption code without authorization. Don't try and bypass passwords. After October 2000, you're going to run into Title 17 problems, federal offense, and there are statutory damages and actual damages and even criminal sanctions embodied in this new law. But there's one exception to this circumvention of technological protection, and it's particularly relevant for this audience. Libraries and educational institutions may circumvent a technological protection if what they are doing is trying to make a good faith determination as to whether or not to acquire a copy of the work. They can do that. A couple restrictions. Number one, it's got to be for a good faith purpose, right? A good faith determination of whether to acquire this work. And the copy that you obtain may not be retained longer than is necessary to make this good faith determination. And the copy may not be used for any other purpose other than to decide whether you're going to purchase a copy of this work. All right, well, does that mean that all copies of copyrighted works are infringing? And here's where we come to the role of limitations. For those of you still with me and keeping track, that's element 3. Now, the rights that are granted to copyright owners in Section 106 of the Copyright Act are subject to 15 separate sections that embody limitations on those rights. And that's expressed in Section 107. And most relevant for us in an educational setting are the fair use exemption, Section 107. For the libraries, there are some reproduction rights in Section 108. And the face-to-face teaching exemptions that are in Section 110. And Deb will be talking a little bit more about those in the second half of the hour. All right, well, I had to have at least one slide on fair use, which is, in fact, codified in the Copyright Act, right? Some people don't know that. It's actually there in the statute, Section 107. And it gives us 4 factors that a court is to consider to determine whether any particular use is a fair use. And specifically mentioned in Section 107 is the notion of making reproductions for teaching purposes, including multiple copies for classroom use. It's right there in Section 107. Now, the application of fair use to the typical law professor's activities in cyberspace is a lot like it is in the analog world. It does apply, but there are no bright line rules. Right? The Supreme Court tells us it's a case-by-case analysis. In fact, what you can say is that the general rule is that there is no general rule about fair use. Now, copyright owners have a different and often much more restrictive view concerning what constitutes fair use. And the 14-year-old boy named Jason, who really runs the internet, right, has a much broader view of what constitutes fair use. And in reality, what the courts have held is somewhere in between. Right? It's in between those two extremes. But your institution is probably risk averse. They don't want a lawsuit. And they may even have guidelines. Chances are they do. Fair use guidelines. And often those guidelines have been influenced by what the publishers, the copyright owners, think is the scope of fair use. Now, when we talk about web postings, right, if you post something to the web, it's accessible to anyone, right? Not just your students, but anyone. And that will weigh against a finding of fair use. It's not really for teaching purposes because, while it's for teaching purposes, it's also for anyone who happens to access your website. And so you might want to consider putting those kinds of material behind a password that only your students are given access to. I'm not going to tell you that putting it behind a password automatically guarantees that it is fair use. It will be a factor that will weigh in your favor in any kind of fair use determination. These cases, take it from someone who spent 3 years of her life litigating one of these fair use, educational fair use cases. They are hard-fought, meaning expensive battles to fight. All right, well, there is another aspect to fair use. And that is, I think it's very important for those of us in the educational environment to understand that there's an aspect of fair use that's kind of use it or lose it. Because the more we as a community of educators, narrowly interpret fair use, the more that becomes the custom. And when somebody starts using more than that, they look like they are exceeding what has been accepted as the definition or the extent of fair use. And if you're interested in this very important concept about use it or lose it, Ann Bartow has written an excellent article in the University of Pittsburgh Law Review about how we as educators should exercise our fair use rights or we are going to lose them. I've written one on we as educators perhaps should not always pay what copyright owners ask us to pay. And on the URL that I'll give you at the end of the presentation, there are links to both of those articles. All right, well, let's say our professor believes that the portions of the summaries that he is posting to the class website, they're behind a password and they're only a portion. And so he thinks he's got a pretty darn good fair use argument. He's not worried about copyright infringement. Well, as a result of the Digital Millennium Copyright Act, he's got something else he has to worry about. And this is referred to now in Title 17 as copyright management information. Right? You now have to be sure to include copyright management information in any copies that you might make. And this provision of the DMCA that has been added applies to digital copies as well as to hard copies. So, what is copyright management information? Well, it's really the 4 W's, otherwise known as WWWW, right? What, the title, who, the author, and when and how, the terms and conditions of use. Now, I know how doesn't start with W, but it ends with 1, right? So I can count it. All right, so you have to include all this stuff, right? Title, author, copyright owner, and the terms and conditions of use, as well as a link to the material if it's available, a link to the CMI, the Copyright Management Information material. All right, well, now our professor, our typical law school professor, is quite web shy, right? He's thinking, boy, there are a lot of things I got to worry about, a lot of possible pitfalls. If I want to make these copies of this material that I find out there in cyberspace and post it to my website, well, how about if I just provide a link to the material instead? Right? I'm not going to make a copy. I'll just provide a link. Is that copyright infringement? Or is it, as we like to say, NMP, right? Not my problem. Or as the Jasons of the world like to say, NMFP. All right, well, I'm sure most of you in the room know technologically what happens when somebody provides a link, right? We've got our user's computer here, a student or someone else out there in cyberspace who has accessed this page on the law school server. Let's say it's my cyberspace law class, and I'm providing some links. One of the links that I provide is to what I call the copyright owner's server, right? To the web page over there, which has some information. Now, when the user clicks on that link, there's no relationship between the law school server and the copyright owner's server. What happens is the user's computer calls to the copyright owner's server and requests a copy of the page. Right? So the only copies that are made, there are no copies of the copyright owner's webpage made on the law school server or made by the law school. The only copies that are made are copies made either on the user's computer or in transit. We know there are lots of copies that are made in transit in cyberspace, and certainly at least a RAM copy, and probably more than that, onto the user's computer. That's where the copies are. So technologically, by providing a link, the professor has not copied or caused to be copied any of the copyrightable stuff, right? Well, why then do people worry about linking if no copy has been made? Well, there are a few reasons why people worry. One is there have been some lawsuits, but the lawsuits don't involve simple linking. What they involve is linking and framing, right, where the link pulls in information within the frame of the website, or deep linking, right, for all you deep linkers out there. Deep linking is the idea of linking to an internal page of a large commercial website, bypassing the home page where all the advertising is. Right? That's deep linking. So we have had some lawsuits about linking with framing and deep linking. And the theories asserted in these lawsuits are not just copyright infringement, but they're trademark infringement and unfair competition as well. Now, we don't have any decisions finding infringement for linking, even in the context of linking and framing, or even in the context of deep linking. There is, in the United States, we do not have any decisions yet. All right, and we don't have any lawsuits that I'm aware of that involve simple linking. So, when we talk about simple linking, right, no copies are made by the linker, so the only possibility for copyright infringement liability is through a theory of contributory infringement. All right, well, some basics about contributory infringement. Contributory infringement under copyright law requires knowledge of the infringing activity and substantial participation in that infringing activity. And there needs to be a direct infringer for there to be liability for contributory infringement. So when we talk about the possibility of contributory infringement for linking, right, for the act of providing a link to some other material, if what you are linking to is material that is authorized by the copyright owner, there's no direct infringer. Right? The person who has posted this linked to material is authorized. And the individual who makes the copies, right, makes the additional copies, the user in that little graphic that I showed you, the user, we pretty much accept at this point that the user either has an implied license to make the copies that they make. Come on, the copyright owner put it out there in cyberspace. They know that to access it, people have to make copies, right? Or we say the user has a fair use right to make those copies. So either through an implied license theory or a fair use theory, we pretty much agree that if the material is authorized by the copyright owner, there's no infringement. But what happens when you link to infringing material? Now you have a direct infringer. Right? The person who has posted this infringing material, which we all know there's lots of infringing material out there in cyberspace. So how's the typical professor supposed to know whether the material is infringing, and it doesn't matter? Right? Well, yeah, it matters because the link might be seen by a court to be substantial participation. Through the link, additional copies are going to be made. Users are going to download more infringing copies. So the link might be seen as substantial participation, but remember there's another prong in contributory infringement, and that's knowledge. Does the linker, the law school professor in my typical law school professor hypothetical, the law school professor, does that professor have knowledge that this material is infringing? Well, what do we mean by knowledge? Certainly actual knowledge. If you know you're linking to infringing material, I think you have a real serious problem. But what about beyond that, right? Do you have an affirmative duty to go find out whether this material is infringing? And this is another place where I think the Digital Millennium Copyright Act provides us some guidance. And it provides us guidance through providing what we are now referring to as safe harbors. The Digital Millennium Copyright Act, specifically Title II of that act, codified now at Section 512, which is soon to probably be Section 513, because Congress, in their meticulous attention to detail, codified 2 Section 512s in the fall. So one of those will be changed to 513, and it looks like it's going to be this one. They codified some safe harbors for online service providers. Right? If you are an online service provider, you can look at Section 512 and see that you have some safe harbor protection from claims of infringement for material that is passing through your equipment, right, transitory communications, that is cached on your system. Lots of caching happens out there in cyberspace. So long as you're complying with the standard technological measures, you're going to get these safe harbors. There are some other details of the safe harbor we'll talk about in a minute. But there are also safe harbor protections for the material that an OSP hosts on their server at the direction of their subscribers, and for linking. All right, so the safe harbors apply to only OSPs. So what's an OSP, right? Can I claim to be an OSP? Well, an OSP is defined under this new law to be providers of online services or network access, or the operator of facilities therefore. So in other words, as an educational institution, if you're providing this kind of access, you are an online service provider under the terms of the Copyright Act. So one can think of a university or a college as merely an OSP that charges tuition instead of monthly service fees. And that means that educational institutions can take advantage of these safe harbor provisions if they want to. They don't have to. Right? It's not a requirement. So what the safe harbors tell us is that if an OSP has knowledge of infringing activity, and this applies to either websites that are housed on the OSP's server or websites that are linked to from the OSP's server, if they have knowledge of infringing activities, then the OSP has a duty to remove the infringing material material or the link to the infringing material. That is, they have a duty if they want to stay within the safe harbor protections. Well, where does the knowledge come from, right? Which leads me back to the original question that led me out into these safe harbors. What constitutes knowledge? Well, the Copyright Act now tells us actual knowledge constitutes knowledge, pretty clear. Awareness of facts or circumstances from which infringing activity is apparent. Probably things like the website says, don't tell anybody, but you can download, this software. Right? Don't tell the police. Don't tell the copyright owner. That's pretty much a fact or circumstance from which infringing activity is apparent. Right? Or knowledge is triggered by receiving notice from a copyright owner that there is infringement. That's another way that you get knowledge that then triggers this duty if the online service provider, which includes these educational institutions, if they want to stay within the protection of the safe harbor. Now, what if we consider the university or the institution to be an OSP and we've got a renegade faculty member, right, who knows they are engaged in infringing activities on the web? Not that ever happens, right? Not that we ever have any professors who know they're infringing material. But let's say we do, right? We've got a professor who's infringing and they know it. They're an employee of the institution. Is their knowledge going to be attributed to the OSP, the educational institution, such that the OSP has a duty to act and it doesn't really even know it, even though one of its employees knows it? And this is one of the places where, under the Digital Millennium Copyright Act, educational institutions got some special protections. And it goes like this. Right? This is codified currently in Section 512, subsection E. A faculty member's knowledge, and it also applies to graduate students who are full-time who are employees of the institution. And a faculty member's knowledge of his or her infringing activities will not be attributed to the OSP if, number one, the material, the alleged infringing material, is not for a course. And it's not either recommended or required for a course in the last 3 years. That's how broad that goes. And the faculty member is not a known copyright troublemaker. Now, what do I mean by a known copyright troublemaker? Well, you are a known copyright troublemaker if your institution has received more than 2 notices in the past 3 years of claimed copyright infringement pursuant to these notice provisions. Okay? If you get more than 2 notices about your activities, you become a known copyright troublemaker, and your knowledge will now be imputed to the institution. And, right, we've got these 3 requirements connected by an and, so all 3 have to be satisfied for the knowledge to not be attributed to the institution. The institution has to promote compliance with the copyright laws, promoting it by providing materials about how to comply with copyright. All right, so that's our special treatment that we got. And notice from a copyright owner will still trigger a duty to respond if the university wants to stay within the safe harbor provisions. All right, now, when I talk about this duty to respond, what exactly happens here? And this is what I like to refer to as the notification dance. And I illustrate it with a timeline. We start out with some material on the web. Right? The copyright owner thinks it's infringing. So the copyright owner sends a notice to the OSP. That triggers a duty. Right? They now have knowledge. They have a duty, and the duty is to expeditiously remove the material, the alleged infringed material. And then if they don't want to be liable to their subscriber for removing that material, they send a notice to the subscriber that says, we took your stuff down. Okay? Now, our typical law professor at this point is totally toast because he hasn't made adequate backup copies. Right? Now, typical law school professors don't do that. So the material is now off the web. Right? The subscriber has gotten notice that their material has been taken down. The subscriber has 2 options at that point. They can do nothing. Right? Their material is off the web and it stays off the web. They might still get sued. We don't know. Or the subscriber can say, no, what I did was fair use. I want my material back up. And so the subscriber would send notice, counter notice, to the OSP. The OSP then must send a notice to the copyright owner that in 10 to 14 days, the OSP is going to repost this material. And the OSP is going to do that. It's going to repost this material unless copyright owner files suit. Okay, so that's the dance. That's this notification dance that goes on. But understand what happens. From this point forward, the material is off the web. If you want to stay within the safe harbor provisions, the OSP is going to take the material off the web. And no court has determined infringement. Only the copyright owner has asserted infringement. And the way they keep it off the web, even if there's been a counter notice, is the copyright owner files suit. They don't have to get a court order. All they got to do is file for a court order, and the material stays off the web. All right, well, winners and losers in these safe harbor provisions that the Digital Millennium Copyright Act added. Well, clearly the OSPs got a safe harbor from direct and contributory infringement liability if they comply with all of these details. The copyright owners, well, they got a really great new enforcement tool, and it's one that relies on their own determination of infringement. And we as the public, the ones who are supposed to be benefiting by the promotion of knowledge and learning in copyright law, we got what? Well, we replaced WH with SQU. That's what we got. All right, well, let me just briefly say a note about the role of educational institutions as OSPs. Right? Universities and educational institutions have to decide if they are going to rely on the safe harbors. If they are, these are complex statutory provisions. You need to have policies and protocols for responding to these notices that you'll start getting, and believe me, you will start getting them. OSU has decided to rely on these safe harbors, and they are getting notices weekly now. You're going to need to designate an agent and register with the Copyright Act, or with the Copyright Office, who your agent is for receiving these notices. In other words, you're going to need to consult your institution's counsel on these issues. Please don't rely on solely what I've said here. Okay? But you're going to have to make a decision whether you want to do that. Right? Are you going to rely on these safe harbors? They are attractive, right? They are an exemption from liability. At the same time, supporting faculty is important. And encouraging knowledge and learning is critical, right? It's our mission. So I just want to make sure you understand that failing to comply with these safe harbor provisions does not automatically make the institution liable for infringement. All it means is you don't have the protection of the safe harbor. We're going to have to go through a standard copyright analysis to decide whether the use is indeed fair. Right? And if it is not fair, well, then the institution may face some liability. But if it is fair, the material will have stayed on the web, it won't have been taken down, and you will have supported your faculty member in the exercise of their fair use rights, and you will have helped promote knowledge and learning, which is what I think educational institutions should do, even if it means a lawsuit. All right, well, let me give you that URL that has links to some of this material and some of the websites and articles that I've mentioned. I hope I've given you some tips on your web activities so that you stay out of copyright trouble, and I hope that where I've encouraged you to exercise your fair use rights, I haven't turned you into copyright troublemakers. I'm going to turn it over to Deb Quentel now so that she can talk to you about some other ways that copyright is relevant to cyberspace and other kinds of digital activities. And we have a little minute here because we're going to have to switch our computers around. All right, thank you. Sure, absolutely.
I just wanted to know, because you have those three things that a faculty member's knowledge will not be attributed if, and the last one, if the institution promotes copyright information, can that be a loophole if they don't promote it?
Yeah, I mean, I think if an institution fails to adequately promote compliance with the Copyright Act, then it's possible you haven't satisfied all three of those criteria.
Is there any mandatory thing that an institution has to?
You know, the statute just talks about providing material. Oh, yeah, so I can be on the... So that's all the statute says. It's a brand new act, enacted in October, so obviously we don't have any case law yet. But it's one of the reasons that institutions have developed these guidelines and these policies so that they can be seen as good guys, right? They are promoting compliance. Oh, they have a renegade faculty member. Please don't hold us liable. We were doing our best. Right?
But it seems to me that maybe they shouldn't be promoting compliance.
I think they should be promoting compliance, but it's a compliance that's not dictated by copyright owners, right, as to what the scope of the law is. And that's where the tricky issues come in. And I think probably Deb's going to be saying a little bit more about how these guidelines get made, things like that. So.
All right, I'm addressing part 2, which is the Copyright Office's report on distance learning, which appeared about 2 weeks ago as a gigantic PDF file. Start to download it, go to lunch, and come back for an interesting document to read. And then also, assuming we have some time here, principles of copyright, or I'm sorry, copyleft, just have it. Before I go into the exact recommendations that the Copyright Office has made, I think it's important to start out with how the Copyright Office defines distance education. The instructor is active in determining the pace and content of the course. Students and instructors are separated by time and space. Then these other factors are just industry and notions that the Copyright Office had about what was going on. The Copyright Office, in creating their report, traced the historical roots of distance learning to correspondence courses. They also recognized a change in technology for distance education from formats of mail, radio, TV to computers, including email, chat rooms, linked to web resources, pre-existing materials, as Lydia talked on, being included, and then also video conferencing. So it's a shift from one-way technologies of mail and radio and TV to an interactive format. The Digital Millennium Copyright Act and Distance Learning report focused on 2 things, the history of where this came from, and then the actual report, which I'd like to briefly give an overview of. The history basically involved 3 entities. In 1994, there were 2 initiatives that sought to develop guidelines interpreting the application of fair use to educational uses through digital technology. A consortium of college and university media centers, an agency for Instructional Technology issued guidelines in 1996 addressing portions of copyrighted works and educational multimedia products. Then also the Conference on Fair Use convened by the Administration's Information Infrastructure Task Force. They prepared draft guidelines relating to the performance and display of copyrighted works in distance learning in nonprofit educational institutions. In 1997, we saw the issue of copyright and distance learning raised in Congress by bills that proposed changing Section 110, which Section 110 of the Copyright Act covers face-to-face classroom exemptions for exclusive rights a copyright owner may have. The amendment that was proposed in 1997 would have clarified that Section 110, subparagraph 2, covered digital transmissions and would have broadened the scope of the exemption. Nothing happened to these bills. They were discussed during consideration of various treaties, and then in the spring of 1998, several senators tried to get parties involved to reach agreement. Failing that, they requested that the Copyright Office, over the course of a few days, make recommendations as to what should be changed. So the initial recommendations that the Copyright Office looked at, and this is pre-Digital Millennium Copyright Act, the initial recommendations included a recommendation for a narrow amendment to Section 110, subparagraph 2, and a proposal for further study. I like proposals for further study. The recommendations were mentioned at the time as being a minimalist approach. So at the time, in 1997, or rather 1998, the Senate opted not to amend Section 110.2 and instead they recommended a study by the Copyright Office. And this study eventually became Section 403 of the Digital Millennium Copyright Act, which claims that after the Register of Copyrights, after consultation with representatives of copyright owners, nonprofit educational institutions, and nonprofit libraries and archives, shall submit to the Congress recommendations on how to promote distance education through digital technologies while including interactive digital networks, maintaining an appropriate balance between the rights of copyright owners and needs of users of copyrighted work. So basically, the scope of analysis that the Copyright Office used since being required, mandated under Section 403 to work, involved three things. First of all, licensing. The Copyright Office notes in their distance learning report that licensing has a number of significant problems. Parties raise the idea of cost. It's very hard for an educational institution to pay for all this licensing. It's hard to find the copyright owners. With the increased time that copyright is now given for protection of authors, authors have the audacity to die and leave no clear indication as who you should contact for permissions. And then some owners simply don't respond to requests. The copyright owners responded to this idea of licensing problems as that fair use was strong and healthy, that could solve any ambiguities, and more efficient licensing systems are being developed every day. Further, the copyright owners believe that expanding Section 110 would harm their emerging markets and risk unauthorized dissemination of the materials. Finally, the copyright owners argued that licensing fees, while a cost of business for the school, are also just one of the regular costs that a school incurs in doing business, just as running electrical bills and buying equipment such as that. The second thing the Copyright Office looked at was fair use. A couple principles to keep in mind here. In its current form, fair use does apply to distance learning, and it also does not exempt all nonprofit educational uses. Not everyone understands that fair use and Section 110 are exemptions that are separate. Fair use claims are intended to be asserted only after the defenses under 110 have failed or don't qualify. So 110 and fair use are not analogous, they're separate. There's also confusion over fair use guidelines, and the problem is that the guidelines are guidelines, they're not statute. So some believe that a simple clarification of more formalized guidelines would be benefit. The downside to having more formalized guidelines is they're formal and then they become law-like in their nature, and there's the fear that they would then be adopted as law by Congress. And finally, the Copyright Office centered on statutory language and what changes should be made to statutory language. So in making these recommendations, the Digital Millennium Copyright Act instructs the Register of Copyrights to consider the need for an exemption from exclusive rights of copyright owners for distance education through digital networks. And the analysis, the Copyright Office mentions in several points in this report that their analysis is limited by amendments to Section 110.2 proposed to the last conference. They also claim 6 months was too short a time to look at everything, and that they stress very highly that this was a limited analysis. They also were given a list of 8 factors to consider in addition to the mandate under Section 403. They were to consider these factors. The focus of the analysis of the Copyright Office was materials delivered to students through digital technology in the course of mediated instruction, and uses analogous to the performance and display addressed in Section 110. These do not address other issues raised by distance learning, such as student use of supplementary material in digital forms, such as course packs, e-reserves, digital library resources. It doesn't discuss the idea of creation of multimedia material by students, and it doesn't discuss the downloading or retention of materials delivered digitally. And the reason for this was the Copyright Office said, we're focusing on 110 subsection 2, what needs to be changed. So there are a few principles that shape the recommendation. First of all, timing. Copyright Office stated that copyright owners and users of copyrighted information should have a chance to work things out. Only when the market is dysfunctional should the government step in. Timing is therefore key, the report states. Policy also was a large concern. When a statutory provision is going to be changed, you have to keep in mind what the underlying policy was. You don't want to necessarily change the underlying policy, but if the statute has become obsolete due to technology, you need to change and update the provision, but you want to be careful about tinkering with the underlying policy. And then finally, you want to balance out the interests of users and owners. And Section 110, as it exists, was intended to maintain a balance between owners and users, so any amendments should keep that change. So the question is, why change Section 110? The 1976 Act was intended to cover, quote, all the various methods by which performances or displays in the course of systematic instruction take place. So updating this section, 110 subsection 2, would allow the same activities to take place using a digital delivery mechanism, while at the same time controlling risks and maintaining the balance of policy between owners and copyright users. There are 9 recommended changes to the statutory language, and I see our time is ticking by, as time does, so I'll move somewhat rapidly through these. The first thing is clarify the meaning of transmission. In Section 110, they talk about transmission. So what you need to do, the Copyright Office states, is clarify what transition means. The second thing is expand the scope of rights covered. Currently, 110 Section 2 exempts only performance and display. And it's performance of a non-dramatic literary or musical work. So if it added rights, limited rights of reproduction and distribution, this would impact in a digital environment. And you also want to limit reproductions to transient copies, things that are not going to be stored, things that are not going to impact on a secondary market. The third factor is clarify what mediated instruction means. The problem here is the instructor's display or performance limits the act. That's what happens in a classroom setting. It's a time-based, space-based situation. But performance and display should be analogous to the type that would take place in a live classroom if you have any amendment to the section. So once a work is posted to a website, it can be displayed or performed at the student's discretion, and they can listen to it multiple times. This is one of the benefits, obviously, of distance learning. It's one of the things that 110 subsection 2 does not address. So the work should be an integral part of the classroom, controlled by the instructor, and the Copyright Office suggests performance or display must be at the instructor's direction. The key is performance or display should be analogous to what happens in the classroom. The fourth point is to eliminate the physical definition, or the definition of physical classroom. The problem is that this definition limits the location and transmission idea. Right now, distance learning, of course, is outside the physical location, so this is a problem. Reception in the classroom or similar places normally devoted to instruction. So distance learning makes this practicality impossible and conceptually obsolete, since the goal of distance learning is anytime, anywhere learning. So the idea is to limit the technology, or use the technology rather, to limit access to students only. Put a password on. Change the idea of physical location, put a password on. The fifth point is add some sort of safeguards for new risks. The problem with the statute now is the transmission of works in digital form poses greater risks. I can take my class material as a student and send it to my 400 closest friends via email. So suddenly the transmission is no longer limited to my class of students. The transmission of works poses greater risk to copyright owners. So you have to do a number of safeguards to minimize this. Place transient copies, or make transient copies rather the rule, so that copies are no longer reasonably necessary to complete the transaction. Institute some sort of policy where you provide copyright information to students to promote compliance with the law. And then finally, use technological measurements to control what is happening. You don't want to intentionally interfere with protections, and you want to protect what copyright owners have. The sixth point is to maintain standards of eligibility. The problem right now is Section 110, subparagraph 2, is applicable to nonprofit educational institutions. Well, there are a couple problems with that right now. And the question is, there are a lot of educational institutions that are profit. And then there are also some educational institutions, or the phrase of how we define an educational institution is becoming broader. What about a corporation such as McDonald's that has a very large in-house training program? Is that educational suddenly? So there's been a suggestion that accreditation perhaps should be the test here. And the Copyright Office determined that this needs further attention. The seventh point is expand the categories of works covered. Right now, the current categories are limiting. So if you look at Section 110, subparagraph 2, it refers to non-dramatic, literary, or musical work. So faculty, though, don't distinguish when selecting work to say whether or not it's in a category protected by 110, subsection 2, or whether it's just a piece of material that they need for their class. So the distinctions have been around for 20 years, and there's a desire to maintain this balance between the various types of material. So the Copyright Office is concerned with walking a fine line here. And there's also concern about markets. In 1976, when the Section 110, paragraph 2, as it is now, was enacted, there was concern about potential harm for audiovisual material or dramatic work. So areas affected by expansion for distance learning would be audiovisual works, sound recordings, dramatic, literary, and musical works. And the recommendation of the Copyright Office is to allow performances of additional categories, but not the entire works. They're very concerned that they're very concerned about an impact on potential markets and secondary markets. Also, sound recordings, when the 1976 Act was written, did not have a public performance right. That's recently been added to the Copyright Act, and there was no thought at the time that the sound performance rights were enacted as to their impact on Section 110. So that has to be considered. And so the idea is to limit the portions. So the question is whether this gratuitous but charming picture of Obi-Wan would be transitional material, not protected, or is it integral to the education? Is it adding something? If it's for entertainment, unrelated background, or transition, it probably shouldn't be included in changing Section 110. If it's integral to education, if we are perhaps studying the force of saber swords on the human body, it might be important. The eighth point is require use of lawful copies. It's recommended that you require the performance or display to be made from a lawful copy. This is analogous right now to Section 110, subsection 1, for the performance or display of AV works. What the result here is this would be limiting the impact on any harm on the market, and it would also eliminate certain things from being included in class presentations or in digital distance learning presentations. A first-run movie, something that you have no access to as a consumer to buy, you can't include in your distance learning. Therefore, it's not impacting on the market. And finally, the last point is add an ephemeral recording exemption. And what's recommended here is that new language be added to Section 110 or 112 rather, that would permit an instructor to both upload a work to a server and later transmit this work to the server or to the student. Section 112 does not cover any of these things, and it's more an administrative clarification point of 112. So these are the key features that the Copyright Act, or Copyright Office rather, has suggested for changes to Section 110, subparagraph 2. We really are out of time at this point, so I'm going to leave you with this enticing slide leading you on to copyleft, and the notion that the reality that this slide presentation will be posted to the CALI website, and I'd invite a discussion online actually of the copyleft principles. I will say that CALI is moving more toward an idea of copyleft, which is not to be confused with public domain. And a lot of our material, including things authored that CALI authored that we own, we will not just be assuming your copyright yet. The things that we do own, though, we will be distributing, we believe, in a more open fashion. Thank you very much for your time.